looked at the laws, particularly the Criminal Justice Release from Custody Special Provisions Act. Well, if you look at that law, which is the law really that enables the CJs to go to prisons to release inmates, if you look at that law, it doesn't talk about pardon. It says the CJ has a right to release inmates who have not been convicted by a court or tribunal, but where their continued detention is unlawful, or the time which they have spent in detention has exceeded the time for, if they had been convicted for the offense, has exceeded the maximum sentence for that offense. So if you look at that law, the CJs cannot grant pardon. One, they cannot even release convicted prisoners under that law. They can only release awaiting trial inmates whose time in the prison has exceeded the maximum time they can spend, even if they were convicted of the offense under which they were charged. So I really don't see, I don't really see where the controversy comes from. CJs cannot pardon.
What about the use of the word amnesty? Does it make any difference?
Again, if you also look at that law, the Criminal Justice Release from Custody Special Provisions Act, there is no amnesty. So let's say, for example, a CJ goes to a prison, releases an inmate that has been unduly kept in prison custody. That release does not bar subsequent prosecution for the same charge. The inmate who has been released cannot say, oh, because the CJ released me from prison, you cannot charge me for this offense again. There is nothing in the law that says that any inmate released by the CJ cannot be subjected to trial for the same offense again. So there is no amnesty. There's no amnesty anywhere.
Let's round up with your thoughts on the key reform that you would like to see in the judiciary, especially as we count down to a new legal year.
Definitely, there's so many issues that one would like to see addressed. But if we should rank them, it should be speedy trials. Matters take too long in court for a variety of reasons. But I believe that the judiciary in particular, being at the apex of our adjudicatory system, can dictate the pace. You know, they can close loopholes. And for example, there's a practice direction in the Supreme Court issued by the Chief Justice of Nigeria that election petitions, matters concerning election petitions, should be given speedy trials. And that happens all the time. So now you see that matters relating to elections, whether they be election petitions or pre-election matters or post-election matters, are dispensed with swiftly. The dispensation which these cases, which these matters enjoy, should be extended to cover all the matters filed in court. We need to find out ways to eliminate delays. The last year, the Lagos State Attorney General had a stakeholders workshop where a lot of issues were raised and discussed. For example, why, if you file a statement of claim, why give the defendant such a long time to react? We can cut down that time. We can cut down all these times for reaction, shorten them, make them faster, make them quicker. There are so many things we can do. I'm an advocate for one that courts, for example, rather than asking everybody to come at 9 o'clock in the morning. So in a particular court, you have maybe 20, 30 lawyers all waiting for their cases. Why not spread it out and give each matter a time frame? So particular maybe 10 cases from 9 to 10, another 10 from 10 to 11, and so on and so forth. So that people don't have to come to court, sit there from 9, whilst their matter will not be called until maybe 1 o'clock at times. So there's so many things that can be done, but we are not short of proposals on all these things. Every year, year in, year out, one arm of the government or the other, they're having workshops, retreats on how to overcome these issues. It is time we dusted up all these papers, all these retreat reports, and put them into plan. I'm waiting for the implementation of the communique of the Lagos State Stakeholders Forum on the Judiciary, which was held last year. So if we do that, then we begin to make progress. We need to, every inch we can grab against delay in court, we need to take it back. So if we grab an inch today, 2, 5, 6, then we're making progress. But to not to do anything and to be on the same spot and be, to be repeating the same mistakes, I think it is high time that the Honorable Chief Justice of Nigeria tackles it, and also other state judiciaries can also do it within their states, so that cases, because it is so frustrating for litigants, and that's why perhaps they lose confidence in the system, when you know that, because the common refrain is, don't go to court because your matter will be there for years. But if we address that, we give confidence in the judiciary a shot in the arm, and the system works better for the benefit of all of us.